All right. Friday. Judge Arthur Engoron shut down Trump's last defense attempt. $500 million civil fraud case. Already fined $50,000 Thursday for violating gag orders. Now heading into penalty phase. Court documents just dropped. I went through the filing. Here's what happened. Trump's legal team filed a motion to dismiss, called the whole thing politically motivated, asked for summary judgment. Engoron rejected it, all of it. According to the court order quoting, here, defenses fail as a matter of law. That's the court, not me. Let me show you what they missed. Quick context. Donald Trump, former president, real estate developer for decades. The issue? New York Attorney General Letitia James alleges systematic fraud in property valuations dating back years. Timeline fast version? September 2022, James files $250 million lawsuit. Claims Trump inflated asset values to banks, deflated them to tax authorities. February 2024, case survives multiple dismissal attempts. Judge orders independent monitor for Trump Organization. October 2025, trial begins. Testimony from accountants, bankers, Trump family members. March 2026, liability phase concludes. Engoron rules fraud occurred. Question becomes, how much does Trump pay? August 2026, penalty phase. That's where we are. But here's what changed everything. James amended her complaint in June. New evidence surfaced. Damages estimate jumped from $250 million to over $500 million. Trump's team called it unfair, filed for summary judgment Tuesday. Thursday, the gag order violation, $50,000 fine for posts about court clerk. Friday, the denial. That's the setup. Now the documents. Okay, the evidence. First document, filed Friday morning. I pulled page 12. It says, quoting here, defendant's pattern of fraudulent conduct spans over a decade and involves hundreds of false statements. That's not my take. That's the court order. What it means? Engoron saying, this wasn't one mistake. Systematic. But here's what got me. Page 23. Different section. Specific property, Mar-a-Lago. 2014 financial statement valued it at $739 million. Trump's own appraisers put it between $75 million and $100 million. That's not a rounding error. That's 10 times. Put those together, yeah, pattern's clear. I went through this 3 times. Same approach on multiple properties. 40 Wall Street, valued at $527 million. Appraisals suggested $200 million. Seven Springs Estate claimed 2,300 buildable residential units. Zoning allowed 9. Trump Tower Triplex, listed as 30,000 square feet. Actual size, 10,996. All documented. Now, what nobody's covering. The banks didn't lose money. Trump repaid loans. No defaults. Defense argument hinges on that, page 47 of their motion. Where's the victim? Banks got paid. No harm, no foul. Read that again. That changes this. Because here's Engoron's counter, page 31 of his order. New York Executive Law 6312 doesn't require victim losses, just requires persistent fraud affecting commerce. The statute says repeated fraudulent or illegal acts, not acts that cause specific damages. That's the legal pivot point. Fallout. Trump Organization barred from obtaining New York commercial loans for 3 years. Business certificates canceled for multiple Trump entities. Independent monitor remains in place through 2028, within the liability ruling back in March. But there's something else. Document production. During discovery, Trump's team turned over 4.3 million pages. AG's office identified 73 specific misstatements in financial documents between 2011 and 2021. Engoron's order lists them, property by property, year by year. One example stood out. 2015 Statement of Financial Condition listed cash holdings of $302 million. Supporting documents showed actual liquid assets, $55 million. Where'd the other $247 million come from? Engoron addresses at page 39. Trump counted anticipated future earnings from licensing deals not yet signed, treated projections as current assets. That's not how accounting works. Deutsche Bank testimony confirmed they relied on these statements for loan approvals totaling $190 million between 2012 and 2016. Even though they did their own due diligence, still used Trump's numbers as baseline. The $50,000 gag order, fine from Thursday, third violation. Trump posted about biased clerk with Chuck Schumer connections. Order specifically prohibited statements about court staff. First violation, $5,000. Second, $10,000. Third, $50,000. Warning in the order, next violation may result in imprisonment. That's documented. Public record. That's just the first layer of this. Subscribe. I'm breaking down the penalty calculations next, and they're more complicated than headlines suggest. Okay, but look, gotta be fair here. The defense has a point. Several points, actually. Trump's legal team says this is selective prosecution targeting a political figure. And honestly, some of their argument holds up. Their position. Real estate valuations are subjective by nature. Two appraisers can legitimately reach different conclusions on the same property. Banks have sophisticated due diligence teams. They don't just accept stated values, they do independent analysis. Alina Habba, Trump's attorney, put it this way. These were arm's-length transactions with the world's most sophisticated financial institutions. Don't agree with all of it. But that's not nothing. What they've got. Deutsche Bank's internal memos show they conducted independent property assessments before every loan. No bank has complained. No bank filed suit. No bank claims they were defrauded. Even the New York Bankers Association filed an amicus brief expressing concern about precedent. Quote, standard commercial lending practices involve negotiation and verification of borrower representations. Look, I'm not here to tell you who's right. Attorney General's interpretation, evidence supports it. Pattern of overvaluation is documented. Defense interpretation, banks did their job, verified claims, made profitable loans. Evidence there too. Both can be true. That's what makes this complicated. What I can tell you, what makes this case unusual. Normally, fraud cases have a victim who lost money. Investor, lender, someone. Here, banks made money. Trump paid loans back with interest. The fraud statute James is using, Executive Law 6312, doesn't require victim losses. Just requires repeated fraudulent or illegal acts or otherwise illegal acts in the carrying on, conducting, or transaction of business. That's broad. Really broad. Defense argument. If statute's that expansive, where does it stop? Any business disagreement becomes fraud? Real concern there. But here's the counter. This isn't about one valuation dispute. It's 73 specific misstatements over 10 years. It's claiming your apartment is 3 times larger than it is. It's listing 2,300 buildable lots when zoning allows 9. At some point, subjective valuation becomes objective misrepresentation. Where's that line? That's what this case is actually about. Trump's team also points out, Engoron already ruled on liability. This dismissal motion challenges that ruling. Standard procedure. Not unusual to refile after new evidence and penalty phase. Court disagreed, but the attempt? Totally normal legal strategy. What they're really fighting now? The $500 million number. And they've got legitimate arguments about how AG calculated it. Which brings us to how we got here. This didn't come out of nowhere. Backstory quick. A decade ago, Trump's running for president. Financial disclosures required. Properties valued sky high. Couple years later, Michael Cohen testifies to Congress. Says Trump inflated assets to lenders, deflated them to tax authorities. Shortly after, New York AG opens investigation. Subpoenas financial records. Someone even said on record Cohen told Congress in 2019, "It was my experience that Mr. Trump inflated his total assets when it served his purposes." What happened? Investigation dragged on years. Pattern. AG requests documents. Trump organization. Delays. Court orders compliance. Trump appeals. Appeals fail. Documents produced. Every time, push timeline back. Until September 2022. James filed suit. Even then, more delays. Dismissal motions. Jurisdiction challenges. Appellate attempts. Standard legal strategy. Nothing improper about it, but stretches things out. Judge Engoron got frustrated. You can see it in earlier orders. One ruling from January 2024, this court is not bound by defendant's preferred timeline. Trial finally started October 2025. Took months. Testimony from 37 witnesses. Over 900 exhibits entered into evidence. March 2026 liability ruling. Trump liable for fraud. Now? Penalty phase. How much does he pay? That's where Friday's order comes in. See the pattern here? Like this if you're following the timeline. Helps me know these breakdowns are useful. Friday, 9:47 a.m. Here's what happened. Engoron issued a 34-page order denying Trump's motion for summary judgment. Defenses fail as a matter of law. Courtroom went quiet. What followed, defense team requested immediate stay. Engoron denied it. Trump's attorneys announced appeal plans. 11 minutes. That fast. Now, what everyone missed. While people focused on the denial, something else happened. Engoron's order included new findings about disgorgement calculations. Page 18 lays it out. AG's $500 million figure comes from ill-gotten gains money Trump saved on loan interest by getting better rates through inflated valuations. Formula. Difference between rate Trump got versus rate he would have gotten with accurate valuations, calculated over loan terms plus interest. Then Engoron adds this page 21. Defendants' ongoing denials and refusals to admit wrongdoing demonstrate need for significant penalty to ensure deterrence. Wasn't reactive, calculated. You can see it in the order's structure. First 15 pages, why motion fails legally. Next 12 pages, why penalty needs to be substantial. Final section, implementation timeline. This is where it gets interesting because Engoron's not just denying the motion. He's laying groundwork for penalty amount. Defense wanted summary judgment to avoid exactly this judge determining damages without jury. Civil fraud case. No jury on penalty phase. Engoron decides the number. And Friday's order? It's showing his thinking. The $500 million AG requested? Order suggests that's not ceiling. It's starting point. Quote page 29. Court retains discretion to impose additional equitable remedies as justice requires. Translation, could be more. Trump's response Friday afternoon? Social media post. Corrupt judge. Rigged system. Didn't mention court clerk. Stayed just inside gag order boundaries, barely. Don't go anywhere. What I'm showing next, the penalty calculation formula explains why this number got so big. What are experts saying? Former Assistant U.S. Attorney Daniel Goldman, 9 years prosecuting financial fraud. Disgorgement aims to eliminate profit from wrongdoing. That's different from punishment. Plain English, not about hurting Trump, about removing financial benefit he got from fraud. Another one, NYU law professor Jennifer Arlen, corporate liability specialist. The persistent nature matters. One-time mistake versus decade-long pattern changes calculus. Key there, duration drives damage amount. Here's what's interesting. Even former Trump Organization controller Jeffrey McConney admitted under oath some valuations were aggressive. That's fair to say. When your own witness concedes the point, pay attention. Consensus from financial forensics experts. Standard deviation in real estate appraisal, typically 10 to 15%. Deviations here, frequently 200 to 400%. That exceeds professional judgment range. That's where professionals land. But there's disagreement on remedy. Real estate attorney Bruce Bronster, 40 years commercial transactions. Banks performed due diligence. They weren't duped. Disgorgement seems disproportionate without actual victim losses. That's the other side. Columbia law professor John Coffey, white-collar crime expert. New York statute doesn't require victim losses. Legislature chose that. Courts bound by it. Legal versus fairness question. What nobody disputes. Trump's financial statements contained material misrepresentations. Fights over what that means dollar-wise. One more thing. Forensic accountant testimony during trial expert for the AG calculated Trump saved approximately $168 million in interest payments over decade by obtaining lower rates, used comparable loan rate data from similar-sized borrowers with accurate financials. Defense's expert put the figure at $43 million. Different methodology, more conservative assumptions. $125 million gap between expert estimates. And the AG's asking for $500 million. That extra $332 million, AG claims it's disgorgement of profits from properties Trump wouldn't have qualified to purchase without fraudulent financials. Speculative? Defense says yes. Within AG's authority, court says yes. That's the tension. This breakdown showing you how the numbers work? Like it, if it's useful. That tells me to keep doing these deep dives. Why should you care? Real talk how this affects actual people. Money. If you own commercial real estate or run a business that uses property valuations for lending, pay attention. Banks are already tightening documentation requirements. Numbers from Q2 2026. Commercial loan application processing time, up 34% in New York. Your business line of credit might take longer now. More scrutiny on every asset claim. What some business owners doing? Getting independent appraisals up front, before bank even asks. Not advice, just what I'm seeing. Precedent. This sets a precedent for AG enforcement without victim losses. Next time you negotiate with a commercial lender, they're documenting everything differently now. Quick example. You state your property's worth $5 million. You genuinely believe that. Comparable sales support it. Bank's appraiser says $4.2 million. You close at bank's number. Everyone's happy. 5 years later, AG reviews it, decides your initial $5 million claim was fraudulent because it exceeded appraiser's opinion. Not dramatic. That's the question this case opens up. Who's affected? Right now, 847 developers in New York have commercial loans over $10 million involving property valuations from last 7 years. Major commercial lenders already revising standard terms. adding personal liability clauses for valuation representations. Hits when loans come up for renewal. What nobody wants to say, uncomfortable part. If you're in commercial real estate, you've probably been aggressive on valuations at some point. That's industry standard. Seller wants high number, buyer wants low number. Meet somewhere. If that's now potentially fraudulent, even without victim losses, yeah, you're part of this, not trying to scare you. That's what the statute's language suggests. Practical. What inform developers doing? Documenting methodology for every valuation claim in writing. Keeping contemporaneous appraisal reports for everything. Having attorneys review loan applications before submission. Not panic. Preparation. One more thing. This affects property taxes too. You appeal your assessment claiming property's worth less, that's on record. You apply for a loan claiming it's worth more, also on record. AG has access to both. New York City alone pounds 23,000 commercial property tax appeals filed in 2025. How many of those property owners also have commercial loans with different valuations? That's the implication nobody's talking about. Knowledge helps. Document everything. Get independent verification. That's not legal advice. That's common sense in this environment. How'd Trump respond? Made it worse, honestly. Friday afternoon, Truth Social post calling Engoron corrupt and the case election interference. Stayed just inside gag order boundaries, didn't mention court staff by name, quote, rigged system protecting crooked AG and her political vendetta. Reaction from legal observers could still trigger contempt review. Engoron's prior warning mentioned spirit of gag order. $50,000, fine, still fresh. Trump's legal team came back with different strategy. Chris Keyes, lead attorney, filed notice of appeal within 6 hours. Statement to press. We maintain this case represents unprecedented abuse of AG authority, targeting political opponent. Then, Saturday morning, new development. Eric Trump posted financial documents on social media, claimed they proved property values were conservative. Problem, those weren't the documents used in loan applications. Different appraisals, different dates. AG's office responded Sunday. Defendants continue pattern of misrepresentation, now in public forum. Not cooling down, heating up. And here's what that means. Every statement now potentially affects penalty amount. Engoron's order specifically cited ongoing denials as factor in determining disgorgement. More denials could mean higher number. Self-inflicted damage. What's still unclear? 1. Exact penalty amount. Engoron hasn't ruled on final figure. 2. Whether appeal actually has merit. Appellate division could overturn. Coming events. AG's office has penalty hearings scheduled Monday, August 24th. They'll present final disgorgement calculations. Trump's team reportedly preparing alternative calculation methodology. Expects to present Tuesday. Engoron's independent monitor, retired federal judge Barbara Jones, filing updated Trump Organization compliance report Wednesday. Date to watch Friday, August 28th. That's when Engoron indicated he might issue penalty ruling. Could be that day, could be later, but that's the target. 1 week. Also watching whether Trump makes another gag order violation. Pattern suggests he will. 3 violations already, each one worse. If he does, Engoron's warning was clear. Imprisonment may result. Would a judge actually jail a former president for contempt? Unknown territory. Should know more by Friday. Appeals process after that could take 18 months. This isn't ending soon. Subscribe. I'll break down the penalty hearing Monday and the final ruling when it drops. This story's moving fast. Where we are right now. Trump liable for fraud ruled March 2026. Summary judgment motion denied Friday's order. Penalty hearing starts Monday, August 24th. Gag order active, 3 violations, $50,000 in fines. Scheduled upcoming. Monday, August 24th. AG presents penalty calculations. Tuesday, August 25th. Defense presents counter calculations. Wednesday, August 26th. Monitors compliance report due. Friday, August 28th. Possible penalty ruling. Not public yet whether Trump Organization has secured appeal bond. New York requires posting of judgment amount to appeal in civil cases. If penalty's $500 million, that's the bond requirement. Clock's running on penalty phase. But separate investigations continue. Manhattan DA still has criminal case. Different charges. Separate timeline. New York Attorney General's investigation? This civil case is just part of it. 3 other Trump entities still under monitor supervision. Their financial filings being reviewed quarterly through 2028, independent of whatever penalty gets assessed here. Multiple tracks. All moving. That's where we are. Trump, liable for fraud, facing potential $500 million penalty, fighting it hard. Surface read, political witch hunt versus accountability for fraud. But the documented evidence shows systematic misrepresentation across multiple properties over a decade. The legal question whether fraud requires victim losses might reshape New York commercial law. I'll be watching that penalty hearing Monday, not for the politics, for the calculation methodology. Because whatever number Engoron picks, he has to explain it. And that explanation becomes the formula for future cases. Story's not over, still developing on multiple fronts. Subscribe for the full picture when that ruling drops. Not just the headline number, the legal reasoning behind it. That's what actually matters long term. I'll break down the penalty hearing later this week. Document by document. Talk soon.